Hi, this is California Estate Planning Attorney Ed Goodson. Today I'm going to talk about how to obtain a free California statutory form durable power of attorney, and I'm going to show you how I'm going to fill it out for me. How you fill it out will probably be different, and if you needed help with that, I could give you legal advice. I'd be glad to talk with you for free, no obligation call, and we'll talk about how you could fill out this form. But in the meantime, this video is not going to include any legal advice. So I want to get a hold of the California statutory form, and I'm going to do a Google search for LA County Statutory Power of Attorney. So get that, LA County Statutory Power of Attorney. I say LA County because it just turns out that the county has a good one there. It's the California statutory form. I'm going to click through to it. I'm going to make it a little bigger, make sure you can see it. It says, it cites the probate code where this statutory form exists. It says the powers granted by this document are broad and sweeping. They really are. So when I fill this thing out, I'm going to be giving my wife and then my two boys the right and the power to manage all of my assets, to do anything with what I own that I could do myself. So that's a pretty big deal. So I start by putting my name. I put my name. I would print this out. This isn't a fill-in form, so I'd print this out, and then I would handwrite very neatly my name right here, and then put my address, and then I would put my wife's name, comma, and address, and then each of my boys and their addresses. Try to fit it all into that line, and then it says to grant all of the following powers, I can initial the line in front of N and ignore the lines. Okay, so there's all these powers. Each one of these powers, so real property transaction, that's one power. It has a big paragraph in the California probate code, in the law, that says what that entails. If I give California real property transactions powers to my agent, in this case my wife, she'll be able to just sell my house, and they won't need my signature. She can sign for me using this power of attorney. And she can do that from the beginning, from the moment that I sign this thing. So it's really important to choose people you really trust. For estate planning purposes, and that's why I want this, I want to initial N because I want her to have all of those powers. And then, it's just, there's just a whole bunch of things that we don't know what's going to come up. I just want to have her have all the powers. So I really got to trust her. And then I've named my boys afterwards so that if my wife's not available, then each of them in turn could act as my agent. If I had special instructions, I could put them here. Let's think about how that might work. Special instructions, I might say something like, this power of attorney only goes into effect once I become incapacitated. But I'm going to tell you right now, I'm not going to put that because my experience is that it's really hard with the HIPAA laws to get doctors to write down that somebody is incapacitated. It's much better to just choose somebody you trust and put it there. All right, then this is a key line right there. I'm going to highlight it. This power of attorney will continue to be effective even though I become incapacitated. Well, that is the purpose of a durable power of attorney. And if we didn't have that line, it wouldn't be durable. It wouldn't continue through incapacity. The rules for all powers of attorney are that they won't continue through incapacity of the principal unless they say so. And the other rule is once the principal dies, so once I die, this power of attorney dies with me. It's just a piece of paper with no power at all once I die. So you need to keep that in mind. Powers of attorney, they go away when the principal dies. It says strike the preceding sentence if you don't want this power of attorney to continue. If you become, well, I do want it to continue, so I'm going to leave it there. Okay, next thing. Exercise a power of attorney where more than one agent is designated. I designated 3 people. So it says if you've appointed more than one agent, you want each to be able to act alone without the other agent joining, write the word separately. So I got to write the word separately across here. Okay, and I might write separately, comma, one at a time. Then I sign it and I date it in front of a notary. Now, technically, this could be valid if I did it in front of some witnesses, but you know what? The banks, the title companies, the CalPERS, everybody who wants to see this thing, they want to see it signed by a notary, okay? How am I going to get a notary? Well, the UPS stores are open, or I can go online and find a mobile notary near me. All right, that's all it takes to fill out the form. So then it just sits there with my estate planning documents. Then if I have a stroke, I get dementia, maybe I get in a car accident, somebody has to make this, management decisions for me, then what they can do is just pull out this document and take it over to the bank. And since I've used the California statutory form, if the bank says no unreasonably, my wife or my kids, they can sue the bank for not using this form, for not allowing them to use this form on my behalf. So really good to use the California statutory form. That's what I use for all of my clients who do estate planning. Hey, if you have any other questions about estate planning, I'd be glad to talk to you. Again, free, no obligation consultation. Just give me a ring. I look forward to hearing from you soon. Thanks a lot. Bye-bye.